Welcome back to my channel, CryptoQ Media. I'm glad to have you back. In yesterday's filing of supplemental authority in the SEC v. Ripple lawsuit, Ripple cited a judge's ruling in a different cryptocurrency-related matter that I previously discussed. The subject was brought before the SEC today. On top of that, I was intrigued. Although Ripple did not raise the fair notice defense, the SEC did so for two reasons that were unexpected. A lot of people, including myself, took note of that. The wording makes it very obvious that the SEC employs asset-grabbing attorneys who are obviously very enraged. Their disappointment at the recent declines in the cryptocurrency market is understandable. The one to which this refers is distinct from the others. They continue to raise the alarm about the necessity of harsh sanctions, claiming that they would be implemented soon. Does that actually mean it will happen? Different people have different standards. What is harsh to some may be mild to others. But what about the nearly $2 billion that the SEC has requested? Personally, I don't think that will occur. Maybe 100 million was the right number, according to attorney Jeremy Hogan. Even at that point, it would be very harsh. Nevertheless, 2 billion is still a long way off. However, I wanted to let you know that this news might be dropping at any minute. It could show up at any second. Perhaps another couple of months will go by. It would have been funny if its release had happened on the same day as the XRP on July 13th. The news we got on Victory Day a year ago will come true, however I can't predict anything else. However, there is a chance that it might be entertaining. As you may remember, there are two separate historical reasons why July 13th is important for XRP holders. Before I begin, let me state that neither I nor anyone I know has any background or expertise in the field of finance. I repeat, under no circumstances should you allow my opinion sway your decision to buy or sell. Making comedic videos about Bitcoin on YouTube is something I do in my spare time. I simply enjoy it. Additionally, for the purpose of amusement. In light of Binance's most recent ruling, the XRP community's lawyer, James K. deserves praise for submitting a notification of extra authority. I did a lot of reporting on that story when it broke. Because, simply put, it was fantastic. The problem is, it just adds to the evidence that everyone is correct. An XRP, that's what it is. To be sure, Judge Holder, who is presiding over that case, entertained Judge Torres. Considering her ultimate decision about XRP and its implications, it is vital to note that the asset itself is not a security. So that's just another major victory. Also, the judge in that case found the SEC asset perk lawyers quite guilty of using overtly deceitful techniques. I'll give you a taste of it since it's tasty and part of the supplemental authority. This is where it is. After that, this was the submitted version. The following letter was sent to Judge Torres by the Ripple's attorneys. The Torres defendant Ripple Labs respectfully submits this supplemental notice of authority in response to the SEC's continuing request for remedies and entry of final judgment, esteemed judge. In the matter of SEC v. Binance, which was partially granted and partially refused, the U.S. District Court for the District of Columbia issued a memorandum opinion and decision on June 28, 2024. Binance was involved in the request to dismiss. The SEC argues that some digital asset sales should be considered as sales of unregistered securities. The court agreed and extended this argument to include sales of the same asset on the secondary market. This is a comment from the court's decision that sides with the defendants on some points and the SEC on others. I really like it since it disproves several of the SEC's main claims regarding XRP and the whole cryptocurrency market. The judge's statement on the Binance case is available here. Intangible digital assets do not meet the requirements stated in the brief 7 paragraphs that comprise our decision. The agency's current strategy of managing this billion-dollar sector through litigation, penny by coin, court after court, is probably inefficient. Moreover, there is always the possibility that the results won't add up, which could lead to confusion for the right people and their potential customers. Tell me what this means. Even though the SEC disputes this, the judge's ruling implies enforcement-based regulation. Without a shadow of a doubt, it has been happening, just not at this very moment. Making such a claim is dishonest. That was heavily emphasized by the judge, wasn't it? Their approach of doing things one courtroom at a time and one currency at a time is under fire. That concludes the quote. All right, this has been going on for quite some time, we've had enough of this nonsense. It is our mutual belief that the SEC is behaving in that manner. A judge's recognition of this in a separate instance is heartening. In fact, I'd go as far as to say it's vindication for the XRP community. Thus, Ripple's legal team continues. According to Ripple's, this proves that the main point of the court's summary judgment ruling was to make it clear whether or not the different XRP sales were legitimate. The lack of specific rules before to that ruling supports Ripple's argument that the court's finding of a strict liability violation on certain of their transactions was reasonable. Despite the possibility of a few transgressions, the quantity is insignificant to suggest deliberate disobedience to the law or call for harsh punishment. An additional warning signal is that the SEC did not address carelessness in its complaint. Obviously, that's true as well. Among many other things, there is something that I find totally ridiculous. So, it can be concluded that there was no intentional wrongdoing or fraud. So far, no charges of fraud have been leveled. Ripple is still aiming for $2 billion despite the fact that it has not caused any financial harm to its clients. At first look, this might appeal to some. I have a good chance of success. Definitely not. The topic of today's update is now at hand. SEC did, in fact, respond. The filing by attorney James K. affirms this over again. What follows is the text. Judges, plaintiffs, and in a polite reply to defendant Ripple Labs' letter, the SEC has addressed a dismissal request in SEC v Binance Holdings Limited, which Ripple argues lends additional credence to its rejection of the SEC's remedy proposal. That is the argument made by the SEC, and it has no relevance on the current remedy action. The previous authority, Waves, was you. This is completely irrelevant, as obvious as it seems. However, it is amusing how the CDC cites this authority using quotation marks. Bill Morgan, an attorney for the XRP community, may have noticed that. I wanted to share this with you right away since it made me happy. The fact that the SEC uploaded the material from this afternoon shows that he is unhappy with the verdict. Instead of being unquoted, it becomes more credible when surrounded by quotation marks. I agree, that is correct. We won't call it an authority since it's little. My bad, it's fine. We need quotations. As I indicated earlier, these lawyers are highly unprofessional. Still, the continuing asset pricks are highlighting one point from the Justice Nance ruling's almost 90 pages that tries to draw conclusions on the efficacy of the SEC lawsuit approach. The decision also recognizes that the SEC has the authority to choose how to handle Binance according to the law. The belief that Ripple should not face harsh consequences as she did not intend to violate the law. But this goes against what the court said about the SEC's actions in the dismissing motion. It is obvious that A is being dishonest because it does not consider the effect of ripples when deciding what remedies are suitable for the breach in this court. The relevant elements were covered since they brought up this case, which involved another Judge Green. The SEC is clearly trying to show off her rippling status, as one would expect from someone in her position. The attorneys are taking these crazy meds, and you're bringing this to light, my God. The judge takes your claims on this page seriously, thus, you should go immediately. Personally, I don't think so. Then the conversation moves on to equitable notes. It would mean a lot to me if you could subscribe and give my channel a like. Farewell for the moment.